the last class, we discussed about the hotel management agreement. But as requested and as I told, let's go through that once again. And then we'll move on to the corporate agreements. And today we'll discuss about the LLP agreement. Let me share my screen and let's go through the hotel management agreement once again. Asset management agreement. Is there any doubt before we proceed? Is there any doubt from the last class regarding the consultancy agreement? Yes, class. Is there any doubt? Okay, I'll take that as no. Just let me know if my screen is visible or not. Paras, can you please confirm? Is my screen visible?
Yes, ma'am, it is visible.
Okay, thank you. So here is hotel asset management agreement. This is the introductory clause. This hotel management agreement hereinafter is entered into so and so date, which is known as the effective date, at so and so place by and between. First party is Atharva Asset Solution, who is the manager, a company incorporated under so and so laws, having its registered office as so and so place, and the owner of the hotel. That can be any hotel. Okay, we have defined him as owner. Now coming on to the recital clause. Owner through separate subsidiaries, hereinafter called as the owners, hold ownership interest in certain hotels, more particularly set forth in Exhibit A attached here to, collectively called as the hotels and individually as hotel. Manager is willing to provide certain asset management services on terms and conditions as set forth in Exhibit B, the services, with respect to the hotels. Owner hereby retains the manager to perform these services. Owner desires to avail itself of the experience, sources of information, advice, assistance, and certain facilities available to the manager, and to have the manager undertake the duties and responsibilities hereinafter set forth on behalf of and subject to the supervision of the board. We already have discussed the services, what all services are covered under this agreement. So basically, he is an expert in providing these services. He will provide all these services in order to ensure that the hotel benefits and hotel makes maximum profit in the coming up year. He will look after all the financial performance, what are the capital expenditure of the hotel, how can the revenue be managed, what are the monthly operations and how they can be reviewed in a better way, what will be the investment plans. He will provide advices regarding the investment plans to the owner, what all contracts he must enter into for the benefit of the hotel, what all investment he should make for the benefit of the hotel, what all loan compliances are there on his part which he needs to fulfill, and how he can fulfill those compliances, have the complete oversight and managing of the investment, from where he should invest, uh, what should be the amount of investment, what should be the term of investment, and what actually will be the result of that investment. He will manage all the capital, he will manage all the annual budget, and he will plan the review plan, so that he can strategize accordingly for the benefit of the hotels for the owners. Okay, so all these are coming under the services of the manager. Let's go on to the first clause, which describes services. Manager agrees to provide these services for the term as defined below in Exhibit B. We have already discussed this Exhibit B, what all services the manager is required to provide in accordance with the terms and provisions of this agreement. Manager will devote such resources as is required in order to perform the services and will have the control of the means and methods used to provide these services. Manager shall use its commercially reasonable efforts to provide the success to the hotels and shall cooperate with the owner or the owners in advancement of the best interest of the hotels. This is pretty simple clause. It says that manager will do and will use all the reasonable efforts to promote the success of the hotels and will cooperate with the owner for the advancement and best interest of the hotel. Now coming on to the second clause, which is the term clause. The term of this agreement shall be so and so years commencing from the effective date unless terminated earlier in accordance with the terms thereof. So basically the term of this agreement is 10 years, but it can be terminated even earlier to the expiry of this 10 years in the circumstances laid herein after. Okay. Additionally, the party may agree to renew this agreement for one additional term or for 5 years, for one additional term of 5 years upon the mutual consent in writing. The parties here, by this clause, agree that they may renew this agreement if they have a mutual consent in writing to do so. That can be up to 5 years, 10 years, depending upon the mutual consent of the parties. Then comes compensation and reimbursement of expenses. The third important clause I told is the expenses. What will be the fees of the consultant? Okay. Owner shall pay and provide the following compensation and reimbursement to the manager. First is the asset management fees, which is the basic consultancy fees. The owner shall pay a one-time boarding cost of rupees 10 lakhs exclusive of GST upon the execution of this agreement. So what is the basic fee? That is one-time boarding cost of rupees 10 lakh, which is exclusive of GST. GST will be applicable as per the laws. Okay. The owner shall pay the manager a monthly asset management fee, herein referred to as base fee, which shall be calculated as 3% of the hotel turnover. The base fee shall be due for each calendar month in or on the 7th day of calendar month, immediately following the calendar month in which the base fee is earned. In the event that effective date falls on a day other than the first day of a calendar month, or if this agreement is terminated on a day other than the last day of the calendar month, the base fee for the respective calendar month shall be prorated based on the number of days within the term. So now here we are saying, so this is very subjective clause. This can be depending upon what your parties agree to enter into. What I am saying here is that there will be a one-time boarding cost when this agreement will be entered into and on the date of the execution. The manager is entitled to get one-time boarding cost, which is equivalent to 10 lakh rupees. Thereafter, he will get a monthly base fees, monthly consultancy fees, which shall be calculated or based on the hotel turnover. Suppose whatever is XYZ amount is the hotel turnover, then the owner will be liable to pay the manager 3% of the complete hotel turnover, and he may pay that amount on the 7th day of each calendar month. Or suppose something is earned in this month of June, so he will be paid in the consecutive month, which will be in July. Okay. Additionally, the owner shall pay incentives to the manager, which shall not be less than 2.5% of the gross operating profit. These incentives, herein referred to as incentives, shall be calculated quarterly and paid within 15 days after the end of each quarter. Now, besides this one-time boarding fees and the base fees, manager, because he is doing a lot of tasks for the benefit of these hotels and for the owner, he is also entitled to some incentives which will be paid by the owner, and it will be calculated based on the gross operating profit. Whatever will be the profit, that will be 2.5% of that profit will go as an incentive to the manager. It can be 2.5% or more depending upon what the parties desire to. Okay, it will be calculated on a quarterly basis. He will be paid for 3 months. At the end of that 3 months, within a period of 15 days. Suppose for the month of January, February, March, he will be paid in April on or before 15th day of April. That is the end of each quarter. All payments under this asset management fees, including the base fees and incentive, shall be made promptly and in full without any deductions or withholdings, and shall be subject to applicable taxes. So this is a simple clause which says that all the payments will be made to the manager promptly and in full without any deductions and without any withholds. Failure on the part of owner to make the payments within the specified timeline shall incur an interest penalty of 18% on the outstanding amount. Further, the manager reserves the right to terminate this agreement immediately if the payments are not made as stipulated hereinafter. So here we are drafting this agreement for a manager. So I have made the clause to protect the interest of manager so that he gets timely payment for all the services he is providing to the owner of the hotel. In case there is any failure on the part of the owner to make the timely payments, first of all, he shall incur a penalty amount which shall be 18% on the outstanding amount, and thereafter manager herein also reserves his right to terminate this agreement if the payments are not made within this stipulated timeline, that is 15 days or 7th day of each calendar month. Okay, any doubt till here? Any doubt? Should I proceed?
Oh, hello, ma'am. Sorry, I joined late. Can you please give me a brief of like what contract are we drafting?
Did you attend the last class or just we?
Oh, no, ma'am, I was out, so I could not.
Okay, so we are discussing. I hope you have attended that consultancy class.
That was the last
To
week se pehle
last,
wala.
yes, last to last class.
Yes,
So it's a part of that consultancy agreement. The on that last to last class, we discussed about who are the consultants and what is the consultancy agreement. And
yes,
in
ma'am.
the last class, we were discussing about the hotel asset management agreement. So here, the manager is a consultant. We have given a different term to this whole consultancy agreement because this is a specific agreement where a manager who is having his expertise in providing services for the hotel and to manage all its finances and to look after its financial as well as operations in order to ensure that hotel makes maximum profit in the coming up years. So here we are hiring a manager who will look after all the strategy, all the finances, all the operations of the hotel in order to ensure that hotel makes maximum profit. So we are doing that agreement. I have gone through the recital clause. For your understanding, I can again go through that recital clause and then we'll proceed. And for the remaining clause, you can refer to the agreement when it will be shared on the group. Okay.
Okay, ma'am.
I'll just go through the recital clause so that you have a gist of what we are doing.
Yeah.
Owner through separate subsidiaries, the owners hold ownership interest in those certain hotels more particularly set forth in Exhibit A attached here to, collectively known as hotels and individually as hotel. Manager is willing to provide certain asset management services on terms and conditions as set forth in Exhibit B, the services with respect to the hotels. Owner hereby retains the manager to perform the services. Owner desires to avail itself of the experience, sources of information, advice, assistance and certain facilities available to the manager and to have the manager undertake the duties and responsibilities hereinafter set forth on behalf of and subject to the supervision of the board. So now here there is a owner. Suppose we are engaging a manager for the asset management of Taj Hotel. Taj has lot of franchises all over the world. Okay.
Yes,
So
ma'am.
here, one particular franchisee or the branch of hotel is known as hotel, and all the other are known as hotels. Okay.
Yes,
Here,
ma'am.
the owner is engaging manager to provide all the asset management services, to like manage what all assets are there with the hotel and how it should be managed, so that it gives the maximum profit in the coming up year to the Taj. Okay. So
Okay.
owner is retaining the manager to provide all those services, and based on his experience, after seeing his experience and what all his advice and assistance, he wants him to provide all those asset management services. Let me go through that services clause also. So what all services he is willing to provide, this manager will be provide. He will be monitoring the financial performance of the hotels. He will oversight what all expenditures needs to be done in the coming up years. He will manage all the revenue, from where the revenue is coming and how it should be utilized. He will make the monthly operational reviews. He will see where the hotel can invest in the coming up year to maximize returns and to optimize his performance. He will manage all the contracts. He will review what all contracts the hotel has entered into in the previous year and what all will be favorable terms, what he should do in order to provide guidance on contractual negotiations. He will look after the investment community. He will provide advice on the loan compliances and franchise affiliations. Where should he open the new franchisee, and what all loans can he take, how can he comply with those loans. He will oversight the operation and managing of the investment, and so on. So I guess you have a picture in your mind that what all services he will provide in order to ensure that there is a proper management of the assets that are available with the hotel in order to ensure maximum profit. Okay.
Yes, ma'am.
Okay. So apart from that, there were few basic clauses which we have discussed. These were of services. What all services are provided, which we have already discussed. What will be the term? It's simple and it's similar to what we have discussed in consultancy agreement. Then there is compensation and reimbursement of expenses. What will be the fees? So here, because this is a long-term contract, we have one-time boarding cost, which will be equivalent to 10 lakhs. Then we will have a base fee. Base fee will be based on the hotel turnover and will be paid on a monthly basis. Then there will be incentives besides this one time boarding fee, and besides this base fee, there will be incentives which will be paid to the manager. And this incentive will be based on the gross operating profit, whatever profit will be earned by the hotel. So 2.5%, or say any percent of that profit, will be given to the manager besides that base fee as an incentive. All the payments will be made promptly, and if there is any delay, first the owner will be liable to pay an penalty interest, which here I have written equivalent to 18%. And manager has also reserved its right to terminate the agreement if there is further delay in the payment. So we are on expenses now. The owner shall reimburse the manager for all the reasonable and customary expenses incurred during the site visits, including but not limited to travel, accommodations, and implementation cost based on the actual expenditure. Such reimbursement shall be made forthwith upon the submission of valid receipts and documentation by the owner. It's pretty simple clause. It says that whatever expenses will be incurred by the manager and its team in visiting the different franchisees of the hotel, in whatever the accommodation cost will be there, whatever travel will be there, whatever implementation cost will be there, in order to ensure that all the services are met, all that expenses will be met by the owner upon raising of valid receipts by the manager. Okay. The reimbursement policy applies to the site visits conducted for hotel properties with up to 100 rooms. Rooms are hereinafter called as the keys. So this reimbursement policy will apply only for the hotel properties which have 100 and more than 100 rooms in that particular hotel. Site visits shall primarily occur in cities or town categorized as tier 2 according to the prevailing classification standards. So there are certain classification standards in the hotel management. So according to that, site visits will be primarily only for the cities and towns which are categorized as tier 2. The manager shall have full discretion in determining the necessity and reasonableness of the expenses incurred during the site visits, provided they align with the objectives of effective management and enhancement of hotel operations. The owner shall not impose arbitrary limits or pre-approval requirements on expenses reimbursed for site visits unless mutually agreed upon by both the parties in writing prior to that visit. So here the manager is free to raise, first of all, he is free to make all those expenses in order to ensure that there is effective management and enhancement of hotel operations, and the owner cannot restrain him or put arbitrary limits upon him for pre-approvals of these expenses. Okay, this clause ensures that manager is free to do all the tasks and to incur all the expenses in order to ensure that hotel management and hotel operations are effectively managed. Any delays or failures on the part of owner to reimburse the manager for the valid expenses within a specified time frame shall entitle the manager to charge a late fee payment or seek other remedies as deemed appropriate. Here also we have a clause in order to ensure that owner reimburses all the expenses within a specified time frame, and if the owner fails to do that, then manager is free to charge late payment fee or seek other remedies as he may deem appropriate. All expenses reimbursed by the owner shall be exempt from the deductions, markups, or administrative fees imposed by the owner, ensuring that the manager receives full compensation for the actual cost incurred. So these expenses shall not be exempted from the deductions, markups, and so on. Okay. Then we have a termination clause. For the termination clause, we have 3 points. Either this termination can be without cause, it can be with cause, and then we have defined what will be the causes. If in case the termination is with cause, what all will be the causes? Okay, let's proceed. This agreement may be terminated by the manager without cause if Capital Lodging abandons the IPO before it becomes effective. In such a scenario, the manager reserves the right to terminate the agreement immediately without being obligated to provide any justification. So this is the reason when there will be a Capital Lodging abandonment by the IPO, then the manager is free to terminate this agreement without any cause. And with cause, either party may terminate this agreement for cause at any time upon 15 days written notice to the other party, unless a longer period is specifically set forth in succeeding agreement. So with cause, if there is any of the following clauses which I'll discuss here in after, then either party, manager or the owner, are free to terminate this agreement by giving a 15 days prior notice. What all can be the causes? First is the material breach of this agreement, but excluding any such breach capable of being cured within a reasonable period of not less than 15 days following a written notice thereof. Failure to make timely payments, gross negligence, willful misconduct, fraud, or violation of law. So first, if there is any material breach of this agreement, and that material breach has to be of the nature which cannot be cured. If there is a possibility to cure that material breach, then of course there will be a reasonable period given to the other party to cure that breach. Second is failure to make timely payment, that will be on the part of owner. Then if there is gross negligence or any willful misconduct, fraud, or violation of law, in that case also this agreement can be terminated before the expiry of the term. In the event of termination of this agreement or for any reason other than a material breach by the manager shall be entitled to receive compensation equivalent to 3 months. I'll go through it once again. In the event of termination of this agreement for any reason other than a material breach by the manager shall be entitled to receive compensation equivalent to 3 months worth the base fee and incentives calculated based on the average monthly earnings over the preceding 3 months prior to the termination, or such compensation shall be paid within 7 days of termination. So what is this clause saying? This clause is saying if for any reason owner decides to terminate this agreement and there is no material breach on the part of the manager, then the manager is fully entitled to receive a compensation which will be equivalent to 3 months. 3 months base fee and the incentives. What will be this 3 months base fee and the incentives? This will be calculated based on the monthly earnings, that is the gross profit, and the gross turnover of the preceding 3 months by the hotels prior to such termination. And such compensations shall be paid within a period of 7 days from the date of termination. Upon termination, the owner shall reimburse the manager for any reasonable and documented expenses incurred by the manager in the performance of duties under this agreement, provided such expenses were incurred in accordance with the term of this agreement. So, in case the agreement terminates before the expiry of the term, then the owner shall reimburse the manager for all the expenses which has been incurred by the manager before the termination of this agreement. Any doubt till here? Any doubt? Should I proceed further? I hope you have got this clause. Is this clear? I hope you guys are not sleeping and one of you can answer.
Yes, ma'am.
Okay. Thank you, Jasmine. Then comes the confidentiality clause. As discussed, confidentiality clause is again a very important clause in all the consultancy agreements because we are sharing some of the very important personal as well as financial information and our trade secrets with the manager, with the consultant. Okay. During the term of this agreement, the owner either directly or through their directors, officers, employees, legal counsel, or any other party shall give manager access to, and the manager will become familiar with various trade secrets, confidential information, proprietary information of the owner, and other information related to the owner, which is hereinafter defined as confidential information. So during the term of this agreement and during the process of providing all these services, of course, the manager will be provided with a lot of information, lot of trade secrets, lot of financial, proprietary, and other information of the owner, which is hereinafter defined as the confidential information. However, this confidential information shall not include any information or material. What all information will not be included in this defined term of confidential information, which is or becomes generally available to the public? First thing, was known to the manager or on a lawful and non-confidential basis from a third-party resource. So these two things are not covered under the confidential information. First, that's generally available to the public, and second, suppose any information which is already available on the website of Taj. So all that information, okay. Second, the manager has got information from the lawful and non-confidential basis from any third-party source. Okay. Manager shall use this confidential information solely for the purpose of performing the services. This term solely is very important over here. Solely for the purpose of performing the services, and upon the owner's written request, the manager may return to the owner or certify the destruction of the confidential information or copies made thereof by the manager. Manager may disclose such information first to those manager parties who shall require the access thereto for performing the services and who are informed of the confidential nature of the information, as may be required by law or to comply with the lawful judicial process. And third is with owner's prior written consent, which shall not be withheld unreasonably. So first, this clause says that this information will be solely for the purpose of performing the services. And if owner requests the manager shall be obligated to provide a certificate of destruction of all this confidential information and the copies made thereto of these confidential information by the manager. And manager may disclose such information to first to the parties, his employees, and the other concerned person who are involved in performing of these services. Second, if they have a court order or there is any judicial compliance which they need to fulfill, for that compliance and to comply with those judicial orders, he can disclose this information to the court and to the judicial officers. And third, if the owner has if he gets a prior written consent from the owner to disclose such information to any third party. Okay. On the expiration of the term of the agreement, both the parties shall be obligated to promptly return all the copies in their possession to the other party, data, records, or other materials of whatever nature or kind, including the proprietary information. And on the expiration of the term or on the termination of the agreement, owner and the manager both are under the obligation to return all the copies of all the information they have in their possession of the other party. Okay. Coming on to the next clause, title. All the rights, titles, and interest in any data relating to the owner's business operations, including without limitation, all the data and information relating to the hotels will remain the exclusive property of the owner, whether or not provided to the manager during the term of this agreement. So this is a pretty simple clause which says that all the information which is being provided to the manager during the term of this agreement will remain the exclusive property of the owner. Then comes the sale of hotels. Upon the sale of any hotel, such hotel shall no longer be covered by this agreement, and manager shall no longer perform the services related to such hotel. Upon the sale of the hotels, whether through a single transaction or through multiple separate transactions, this agreement shall automatically terminate as of date of the sale of the last hotel. So I'll explain this clause. Just give me a second. Suppose the owner has 6 hotels in his name, naming as one is star, one is 2 stars, third is XYZ, then there is ABC Hotel, then there is GHF Hotel. Okay. So, if in case the manager is looking after the services of all these hotels, and if the owner decides to sell this 2-star hotel to some other party, to a third party known as, suppose, Rakesh, okay, then the liability or the obligation of the manager with respect to this particular 2-star hotel will come to an end on the very date the owner sell of this hotel to Mr. Rakesh. But he will still be liable to perform the services for all the remaining 4 hotels. Okay, getting my point? But suppose he is in through the owner of the hotel, through multiple transactions, are selling of the hotels. First, he sold this 2-star, then he sold this star, then he sold this XYZ hotel, and then he sold this GHF hotel. Still, the owner will be liable to maintain and perform all the services for this ABC hotel till the date this is sold out. Okay. And the day this last hotel is also sold out, which is the ABC hotel, this agreement will automatically be terminated. I hope this is clear. Okay. Then comes the duties of manager. The manager undertakes the responsibility of providing comprehensive asset management services to the owner, which encompasses strategic planning, operational oversight, and financial management aimed at optimizing a performance and value for the hotel properties. The duties of the manager will include, but will not be limited to, all these. First is volume ramp up, which means the manager shall devise and implement strategically designed solutions to optimize the occupancy rates and maximize revenue streams, ensuring sustainable growth and profitability for the hotel property. So he will ensure that we go up and up on this ramp volume. Okay. There is maximum occupancy in the hotel rooms. We can generate maximum revenue streams and we can ensure sustainable growth and profit for the hotel properties. Second is he will maintain a high demand and growth management for the hotel. He will through tailored strategies shall be developed by the manager to capitalize on market demand spikes, facilitating seamless expansion and scalability while maintaining service excellence and brand integrity. He will ensure that there is a high demand in the society for the growth management of the particular hotel. He will make sure that there is brand integrity for the hotel. Then third is the performance stabilization. Through proven methodologies, he will mitigate fluctuations in the performance. He will bolster operational resilience and enhance the long-term sustainability of the hotel properties. So he will make sure that there is a performance stabilization. He will take all these steps in order to ensure present as well as future stability for the hotel. The turning point, asset value preservation. Specialized intervention shall be provided by the manager to counteract asset value depletion, safeguarding the investments made by the owner and fostering enduring value appreciation. So, of course, he will make sure that there is no value depletion of the asset. He will safeguard what all investments the owner have made. He will advise the owner accordingly to invest and to withdraw his funds. Okay. Then comes what all will come under the authority of the manager. Pursuant to the terms of this agreement, including the restrictions included in this herewith, and subject to the continuing exclusivity authority of the owner hereby delegates to the manager the authority to perform the services described in clause 8. So, manager has all the authority to perform all these duties, all these services to perform as has been described in clause 8. The manager shall have the power to delegate all or any part of its rights and powers to manage and control the business and affairs of the owners to such officers, employees, affiliates, agents, and representatives of the manager as it may deem appropriate. So this clause simply says that manager may also delegate the work to further his officers or to his affiliate, but he has to ensure that the work is done. Any authority delegated by the manager to any other person shall be subject to the limitations on the rights and powers of the manager specifically set forth in this agreement. So manager, while delegating the services and the powers to further parties, he has to ensure that he does not breaks or he does not go beyond the limitations of what all rights and powers he has under this agreement. Notwithstanding the foregoing, the manager may not take any action on behalf of the owner without the prior approval, intimation to the owner or duly authorized committees thereof. The acquisition or disposition of any investment, including any financing of such investment, will require the prior approval of the owner, any particular member, officer specified by the owner, or any committee as the case may be. So before making any approval or before doing any acquisition or disposition of any investment, manager is obligated to take a prior approval or at least to intimate the owner or his duly authorized person before making such disposition or acquisition of investment. Then comes record and access. Who will maintain and how the records and who all will have the access to those records. The manager shall maintain appropriate record of all its activities herein under and make such records available for inspection of the owner and by the council, auditors and authorized agents of the owner at any time or from time to time during the normal business hours after the due service of prior written notice. The manager shall be at all reasonable times have the access to the books and records of the owners. So first, the manager will have all the records be maintained and he will provide full access to the owner to come and investigate or inspect all those records at any time during the normal business hours. But that inspection should be done by the owner after providing a due notice to the manager. Other activities of manager, what all will be covered under the other activities of manager? Nothing herein contained shall prevent the manager from engaging in other activities, including without limitation, rendering of advice to other persons, and the management of other programs advice sponsored or organized by the manager or its affiliates, nor shall this agreement limit or restrict the right of any member, manager, officer, or employee of the manager or its affiliate to engage in any other business or to render services of any kind to any other person. The manager may, with respect to any investment in which the owner is a participant, also render advice and service to each and every other participant therein. So this clause simply provides that manager is free to do all the other programs apart from the providing of services to the owner. But of course, that should not come between the interest of the owner. Relationship between the manager and the owner and the manager do not intend to form a joint venture, partnership, or a similar relationship. Instead, the parties intend that the manager shall act solely in the capacity of an independent contractor, advisor for the owner. So he will be an independent owner he will be an independent contractor or the advisor for the owner and is not entering into any kind of partnership or a similar relationship with the owner. Nothing in this agreement shall cause the manager and the owner to be joint ventures or partners of each other, and neither shall have the power to bind or obligate the other party by virtue of this agreement except as expressly provided in this agreement. So they are not bind by any sort of agreement, any sort of other party agreement by this agreement. Manager representations and warranties. What are the representations and warranties that a manager should give before entering into the agreement? He's giving that it possesses the necessary expertise, qualifications, and experience. Then he says the manager represents and warrants that by engaging the manager, the owner is guaranteed to minimum saving of 10 to 15% based on manager's proven track record. So other guarantee he's giving is of 10 to 15% proven. As per his proven track record, he is giving 10 to 15% of guaranteed saving to the owner. The manager represents and warrants that it will perform its services in compliance with all the applicable laws, regulations, and industry standards. Thereafter, the manager is saying that it will use its best efforts and judgments in providing the services, but does not guarantee specific outcomes. This is again important, that though he will ensure that he's used best of the strategies and efforts to provide the services, but he is not providing any sort of guarantee for specific outcomes. Then the manager is representing that he will disclose any conflict of interest that may arise in the course of providing the services under this agreement. Thereafter, he will maintain the confidentiality of all the proprietary and confidential information. Thereafter, he warrants to the owner that the execution and delivery of this agreement does not, and the performance by the manager of its obligation herein under, will not, with or without giving the notice or the passage of time or both, violate any judgment, writ, injunction, or order, arbitrator, government agency to which the manager is subject. This is saying that he represents and warrant that he will not violate any of the judgment or order or any of the instructions given by the government agency. Then what all representations and warranties is given by the owner? The owner is representing and warranting that, first of all, he has complete right and power to enter into this agreement. Then he holds a valid and legal title with respect to the hotel properties, and he has the right to engage the manager. Then he is representing that the hotel properties are in compliance with all the other applicable laws, regulations, and ordinances. Then that he has a financial capacity to fulfill the obligations under this agreement and to pay the fees and expenses of the manager. Then that he has obtained all the adequate insurance coverage from the hotel for the hotel properties. There is no other agreement which may create conflict or will prohibit the owner from entering into this agreement or from performing the obligation set forth in this agreement. Then the owner represents and warrants to the manager that the execution and delivery of this agreement does not, and again the same clause that how the manager was representing that nothing in this agreement will be in violation of any of the order, writ, or any of the judicial instructions. Similarly, the owner is also representing the same. Any doubt? I hope you guys are not sleeping.
No, ma'am.
Okay. Then comes indemnification and limited liability. This is a pretty simple clause. We have discussed this in consultancy agreement also. Let me go through it once. In performing the services, manager is acting solely in advisory capacity to the owner, and unless caused by the gross negligence or willful misconduct of by the manager, breach of this agreement by manager, or act and omission by manager constituting cause, manager shall not be liable directly or indirectly for any event or occurrence or in connection with the hotels for any debt or liability whatsoever incurred. So first of all, it's saying that manager is acting solely as an advisor for the owner, and unless there is a gross negligence or willful misconduct on the part of the manager, manager shall not be liable for any direct or indirect losses that are being caused to the that may incur to the hotel. Then it says that owner shall indemnify and hold harmless the manager from and against any kind of loss, claims, damages, cost, which is hereinafter defined as the liabilities arising out of or incurred in connection with the ownership, management, or operation of the hotels. It is saying that owner will indemnify and hold harmless the manager against all the losses, expenses, cost. Similarly, The manager's responsibilities are limited to providing the advice and recommendations to the owner, and the manager shall not be held liable for the implementation and consequences of the advice unless explicitly caused by the managers. Again, it's saying the same thing, that manager is only responsible to provide the services, but any of the outcomes or the consequences which are not profitable to the owner will not be made the liability of the manager. Okay. Then comes the reporting. Who will report and how that will be done? The manager shall provide regular comprehensive reports to the owner detailing the hotel's operations, financial status, and any significant developments or issues affecting the business. Such reports shall be submitted quarterly within 15 days. Pretty simple. The report shall include a thorough analysis of hotel's operational management. So basically, this clause is saying that he will provide a thorough analysis and a comprehensive, detailed financial summary and the statements, balance sheets, and everything accurately to the owner on a time to time basis. This is what this clause is saying. And he will receive a review of after reviewing those reports, the owner will provide the feedback and then will request the manager to do certain to provide some information if required, or to clarify any information if required. Rectification will be done by the manager based upon the recommendations or the clarifications, feedback provided by the owner. In the event the owner indemnifies any deficiencies or concerns regarding the manager's performance or services, the manager shall promptly be notified in writing by the owner. Suppose in case the owner is not satisfied with the work of the manager, or if he sees any deficiency in the performance of services on the part of manager, he will be obligated to first promptly notify the manager, and vice versa. Such notification shall include detailed information regarding the identified issues and the specific areas requiring improvement. So, owner will provide a detailed information on what all areas they want the manager to work upon and improve. Upon the receipt of the notification, the manager shall have a reasonable period to rectify and address those identified issues. And during that period, the manager shall be afforded with full cooperation and access to all the resources by the owner, which may facilitate that process effectively. Throughout the resolution process, the manager's reputation and standing in the industry shall be safeguarded by the owner. So, of course, during that resolution process, owner will not spill anything about the deficiencies or the issues he has with the manager, because this is the process during which he's trying to resolve all the issues. So owner will be obligated to maintain the reputation of the professional reputation of the manager during this resolution phase. If the manager fails to rectify those issues within the specified period, the owner may provide further notice and manager shall undertake immediate corrective measure. So again, if he is manager has failed to rectify these issues, the owner will again provide him a notice to undertake that he will take the corrective measures in so and so days. Both the parties shall collaborate in good faith to resolve the disputes. The manager shall be given reasonable opportunity and resources to rectify any issues before taking any other coercive action. Then comes recognition. So besides the incentives, besides the base fees, besides the one-time boarding fees, and besides all of the expenses being incurred and being paid by the owner, there are few of the recognition which the manager is also entitled to. Now let's delve into this clause. The owner hereby undertakes that in the event of exceptional performance or the achievement of predetermined milestones, the owner shall acknowledge and recognize the manager's contributions through incentives, bonuses, or other appropriate means as mutually agreed upon. So this is in addition to what all we have discussed earlier. The owner and the manager shall establish a clear criteria and benchmarks for determining the exceptional performance and milestone achievements. These criteria may include but are not limited to: first, exceeding revenue targets; achieving exceptional guest satisfaction rating; implementing innovative strategies; receiving industry awards and accolades. So what will be these recognition based upon? If in case the manager is able to achieve these milestones of implementing some great innovative strategies for cost saving and revenue enhancement of the hotels, then if he generates exceeding target, if he exceeds the targeted revenue generation for that particular month or year, if he is able to achieve guest satisfaction ratings, exceptional guest satisfaction ratings, and so and so, if the hotels get some industry awards, if the owner gets some industry awards due to the manager's effective performance of services, then in all those cases, the manager will be entitled to the recognition. In the cases where predefined milestones are achieved, the owner shall be duly recognized in accomplishing these milestones and may provide additional rewards or incentives as deemed appropriate. In form and the form and extent of recognition, including incentives, bonuses, and other means of acknowledgement, shall be mutually agreed upon by both the parties in advance. So, what all recognition the owner is willing to provide to the manager, this will be pre-decided between the parties while they are deciding these predetermined milestones. Okay, so suppose the owner says or suppose the owner is making a milestone that we will generate so and so revenue by the end of this year, and if the manager is able to get so and so revenue for the hotel at the end of this year, then the manager will be entitled to free trip to Europe. Okay, suppose this is a recognition which has been pre-agreed between the parties, and if the manager is able to exceed this targeted revenue, then the manager will be entitled to that recognition of a free trip to Europe. Okay. The owner shall ensure that any additional rewards or recognition are provided in a transparent and fair manner, taking into account the manager's contribution and overall success of the hotel assets. And this is simple. Then comes the assignment. This assignment may be assigned by the manager to an affiliate with the approval of the owner. So this assignment is similar to the delegation of the task, but this has to be done with the prior approval of the manager. Delegation says that manager may delegate to its employees or to any of the partners, but here it's saying that it is assigning the task, complete task, to some other person, to a third party, but that can be done only with the prior approval of the owner. The manager may assign any rights to receive fees or other payments under this agreement without obtaining a prior approval of the owner. So, manager may assign the rights to receive fees and payments and expenses on behalf of him without the approval of the owner. This agreement may not be assigned by the owner without the consent of the manager, except in case of an assignment by the owner to a corporation or other organization which is a successor to all the assets, rights, and obligations of the owner, in which case such successor organization owner shall be bound hereunder and by the terms of the said agreement in same manner as the owner are bound by this agreement. So, what is this part saying? This part is saying that yes, the manager is free to assign all the tasks, but the owner is not free to assign the obligations and the duties under this agreement to any other organization or to any other corporation without the prior consent of the manager. If he is doing so, he requires a just give me a second. Just give me a second. So sorry, guys. There was someone at my door. Okay. So this clause is saying this agreement shall not be assigned by the owner to any other person without the prior consent of the manager. And if in case this is happening, this can be only to a successor organization which is having the same set of duties, which is having the same set of responsibilities as the owner was having under this agreement. Then comes the miscellaneous clauses. Jurisdiction and the dispute resolution. Okay, we are about to finish this. This agreement may be executed in any number of counterparts, each of which shall be deemed to be original as against any party whose signature appears thereon. So this is saying that there can be n number of counterparts to this agreement, and if the parties have willfully signed to that counterpart, that part will form a part of this agreement. The titles of the paragraphs and subparagraphs contained in this agreement are for the convenience only, and neither party form a part of this agreement, nor are they to be used in the construction or interpretation thereof. Words used herein, regardless of the number and gender specifically used. These are the some basic clauses. You can go through it once I'll share the agreement. If you have any doubt in this particular miscellaneous clauses, you can ping me up over the WhatsApp and ask. Then comes the jurisdiction clause. This is again something we have already discussed during the consultancy agreement. What all laws will be applications and which state will have the jurisdiction, which court will have the jurisdiction if any dispute or claim arises out of this agreement. Then comes the dispute resolution. So parties first will be given a specific time to settle the dispute between them. And if after that time period, expiration of the time period, still the dispute remains, then they will refer to the arbitration method. They may appoint sole arbitrator and they may follow. Now here the seat of arbitration is Delhi NCR. That seat will be depending upon where the cause of action has arises and where the parties have their particular registered offices. Okay. So this is all about the hotel asset management agreement. This is exhibit 1, which will contain the list of hotels. What will be the name of hotel? What will be the city? What will be the state? How many rooms will be there? Who is the manager? So this manager is the manager of the hotel who manages the hotel and not the expert or the consultant. Okay, and who is the owner? Then comes the services. Okay, we have already discussed this. Any doubt in this agreement? I hope now it's clear. Any doubt? You want to ask me anything? This is a bit technical agreement, but it is more or less similar to a consultancy agreement. So I was trying to explain you that consultancy agreement can be as simple as we discussed in the last class and can be as comprehensive, detailed and technical as in this hotel asset management agreement, depending upon what all tasks a consultant is performing and what all services he is willing to provide and what all expertise he has. Any doubt in this agreement? Speak up, guys. I hope you are not
No,
sleeping.
ma'am.
Okay. So what are we next proceeding to?
Ma'am, in this, like the manager who is being hired, that's when the contract is made with amongst the manager and the owner, right?
Sorry, come again.
Ma'am, this is the contract that we drafted for the manager, right? We are in the manager side.
Right. I have drafted basically supposing that my client is a manager. Client is the consultant and I am drafting the agreement
Right. So, ma'am,
to ensure that all the interest. Yes.
no, sorry, I couldn't hear you.
No, continue.
No, so that's what my question was. Like in consultancy, so I actually didn't get like how the consultancy thing works.
Works.
Yes, ma'am.
So basically, consultant is any person who is having an expertise in a particular field. Okay. I told you it can be an HR consultant, it can be an IT consultant, it can be a tax consultant, GST consultant, as we discussed in the previous agreement. Okay.
Yes, ma'am.
So here, a consultant, what is we have defined him as manager. Here, the consultant is a company who has his expertise in managing the finances of these companies. Okay.
Right.
So he is basically a financial expert who ensures that any company who he is providing advices to or with whom he is engaging with makes the maximum profit.
Right. So that's where I was confused. Like, the manager, is he like an individual or does he belongs to a company? That's what I
So
was.
here it's a company. If you see clause A, it
Yes,
says
ma'am.
Atharva Asset Solution. So it is a company over here,
Right.
because of course it's not if practically thinking, it's not possible for an individual to look after so many hotels. Okay,
Right.
he
Right.
needs a team. So here it's a consultant company, like we have discussed in the while we were discussing the PPT. So I have discussed that it can be either an individual consultant, it can be either a freelance agreement who provides consultancy advices and consultancy services on a freelance basis. It can be either a company or a business entity. Okay.
Got it, ma'am.
So like legal firms, so a lot of legal firms use the term legal consultants. So there it is a complete firm which is expert in law and is providing their services. Okay.
Right. Got it.
Any other doubt? Any other person has any other doubt? Okay. So now we'll proceed on to the next type of agreements, which are corporate agreements. Let me share my screen first.
Can we take a 5 minutes break, ma'am?
Yes, of course, of course. I'll come back at 11:15. Okay, we can start at 11:15.
Okay, sure.
Okay.
Ma'am, till when is the class going to happen?
Till 12. 12.
Oh,
It's
oh,
a 2 hour class because yesterday I was busy in some tasks, so I could not take it up yesterday.
oh, okay, ma'am.
Should we start? Just drop a message in the chat box if you're ready to start. I have not received a single message. सब भाग गए क्या?
If you guys all are ready, so we can start. Ayaz, Ojasvi, Priyanka, Bhavya, Naseem, Paras, Rajdeep.
Yes, ma'am, we can start now.
Okay, good. So now we'll discuss limited liability partnership. What is limited liability partnership? Just tell me. Now, first tell me, what do you understand by a limited liability partnership? What do you guys understand? I know guys are tired, but let's make it a bit interactive so that you don't sleep. What do you understand by a limited liability partnership?
Limited liability partnership, it means the liability will remain on upon that company only, and not goes to that beyond that company. So, like if they are having some shareholders, then it will not go over there.
Right? Any other person? Who can explain me better? Yes? Ojasvi, Priyanka, Rajdeep, Paras, anyone? Limited up to the shareholding of the partners. Yes, Paras. Good.
Ma'am, in limited liability, it can be seen in this way also, that the partners will be liable to only to that amount. I mean, that the amount which they invest in the company, and not beyond that. And
Yes.
moreover, to that limit,
Mhm.
up to which they agree to be liable for.
Yes. Correct. Correct. So let's move on to this. A limited liability partnership, which is an LLP, is a business structure that combines the benefit of a company as well as a partnership. LLP members enjoy a limited liability, meaning that they're not personally responsible for the business debts beyond their contributions. Internally, LLPs operate based on a mutual consent among partners, similar to a traditional partnership. So, as Ojasvi and others told, that partners in an LLP are only liable to the amount they have contributed and not beyond that. Suppose they have contributed 20% to a particular partnership or the business structure, then that particular, suppose a person invests 20% or contributes 20% in the company, so he will be liable only for the 20%, and any other debts which will be beyond that 20% will not come under his liability. What are the key features of LLP? First is the limited liability of the partners. Each partner's liability is limited only to the capital contribution. We have already discussed this. Partners are only liable for their own wrongful acts, not for the negligence or misconduct of the others. So each partner is responsible for their own acts and omissions and shall not be made liable for any other negligence or misconduct which is happening on the part of other partners. It is a separate legal entity. An LLP is a legal entity separate from its partners, ensuring perpetual succession. So, suppose there are 10 partners in an LLP, but still, suppose an LLP is LPJ LLP, okay? then that LPJ LLP is a separate legal entity and their partners are separate persons. Okay, their partners will not be a part of that separate legal entity. Number of partners, an LLP can have minimum 2 partners, but there is no maximum limit. Audit of accounts, annual accounts must be maintained and audits are required if contributions exceed 25 lakhs or annual turnover exceeds 40 lakh. LLP must file a statement of accounts and solvency with the ROC annually. So LLP is obligated to maintain a proper books of account and shall register that with the registrar of companies annually if their contribution exceeds 25 lakhs and their annual turnover exceeds 40 lakh. Okay. Then comes the admission and retirement of partners. LLP continue to exist regardless of any changes in the partnership. As told, LLP in itself is a separate legal entity and it is not affected by the existence or the retirement of the partners. Designated partners, LLPs must have at least 2 designated partners, one of whom must be an Indian resident. For example, in an XYZ LLP, there are 2 partners. One is J and the other is K. J and K took rupees 20 lakh loan but only contributed 5 lakh each. Now, instead of that agreed 6 lakh and rupees 4 lakh respectively, if XYZ LLP can't repay the loan, the creditors can only recover up to 10 lakhs, the total capital contributed. J and K are not personally liable for more than their contribution. So, what is this example talking about? Suppose there is XYZ LLP which has taken 20 lakhs loan. But the partners, there are 2 partners in that XYZ LLP. One is J and one is K. Both of them have contributed 5 lakhs each. So, in case the creditors tomorrow comes to recover that loan, they can only recover 10 lakh from these partners, and these partners J and K will not be liable to pay beyond that 10 lakh, that is 5 lakh each, or 6 lakh and 4 lakh respectively, what they have agreed. Okay, any doubt? Any doubt, class?
No, ma'am.
Okay. What is the basic differences between a partnership and a limited liability partnership? First of all, partnership is governed by Partnership Act of 1932 and the LLP is governed by Limited Liability Act of 2008. Second, partnership. There is no compulsory registration required for a partnership firm. Even there can be unregistered firm, but the only drawback is you cannot sue an unregistered firm. But a compulsory registration with the ROC is required for an LLP. Then, in partnership firm, all the partners are jointly liable for all the debts, all the losses, and all the liabilities. But in LLP, as discussed earlier, partners have a limited liability which is equivalent to their contribution to that particular firm. Partnership has no separate legal entity, but LLP has their separate legal entity, which we have discussed earlier in the last slide. Partnership firm is run according to the different laws and rules, regulations as per the state, but LLP is governed by one act, that is the Central Act, and all over the India it has same rules and regulations. Then the partnership firm is not obligated to file returns, is not mandated to file returns with the ROC, but annual returns are mandated to be filed by an LLP firm. Can a minor person become a partner? Yes, it is allowed in a partnership firm, but it is not allowed in a limited liability firm. What are the general clauses in an LLP agreement? First is the term of the LLP agreement. Then what will be the contributions of each of the partner? What will be their right and duties? What will be their voting rights? What all profits will be shared between them? What will happen if in case there is any retirement or an admission of a new partner, or in case of death of any of the partners? How is the term of LLP borrowing works? What all compensation, which includes salaries and remuneration of the partner, how will that be governed? And what all will be the process of amending an LLP agreement? Then there are certain other clauses which will clarify more about the LLP liability for each partner's sections, how an LLP can be converted into a partnership firm and vice versa, what will be the interest rate on partners' contributions or loan they have taken, what will be their ownership interest, what will be the restrictions on partners competing with the LLP. Any doubt till here? I guess you have understood the background of what an LLP is. If yes, then we can proceed further with the drafting of the agreement.
Yes, ma'am.
I hope my screen is visible to you.
Yes, ma'am.
Okay. So this is a limited liability agreement. This agreement of limited liability partnership, hereinafter known as the agreement, is made at Mumbai on so and so date, which is known as the execution date, by and amongst, first is Mr. Bill, who is having Aadhaar number so and so, residential address at so and he is defined as partner 1. Then second is Mr. Steve, having his Aadhaar number as so and so, residential address as so and he is defined as partner 2. Then is Mr. Warren, who is having his Aadhaar number so and so, residential address so and he is defined as partner number 3. So herein in this agreement, partner 1, 2, and 3 shall be collectively referred to as partners and individually as partner 1, 2, 3. Now, what is the business of LLP? The business of LLP shall be to manufacture alcohol-based scented sanitizer under the name and style Cleanup and distribute it through designated distributions across India. The same shall be exported through the ports mentioned in Schedule 1. To open a boutique store in Delhi NCR and sell personal care products, including but not limited to the soaps, shampoos, body wash, perfumes, and chargers. So, what is the business of an LLP here? First is to manufacture alcohol-based sanitizers and to distribute it in the areas as is export through the ports and to distribute it in the areas across India. What all ports and what all mediums will be included in this export business are defined under Schedule 1. The second business, what this LLP is into, is they will open a boutique store in Delhi NCR and they will sell some of the personal care products, which will be including but not limited to the soap, shampoos, body wash, perfume, chargers, and so on. So this is the background of what are we entering into and what is the business of LLP. Now comes the second important clause. What is the registered office of an LLP? Before we proceed further, one of you can let me know what according to you a partner should know while entering into the agreement. Suppose if you are one of the partners entering into this partnership agreement, limited liability partnership agreement, with such kind of business LLP, what all you should have information about?
They are registered in certain authority or not, or what are the documentations and the means evidence of the documentation basically, where their office are and all this. What are their capitals and like this?
Yes. So the first clause accordingly talks about the registered office of the LLP. First of all, before establishing any business, we should know what will be the registered office of that particular business. The business of the LLP shall be carried out at and from the shop number so and so, Gurugram, Haryana, which shall be registered office of the LLP, and at and from such other places as shall be agreed by the partners unanimously from time to time. The LLP may change its registered office by following the procedure as laid down in the said act and with the consent of the partners. The LLP may, in addition to the registered office address, may use other addresses for their purpose of correspondence as its address for service of documents under so and so LLP Act with the consent of the parties. So, what is this clause saying is that one will be the registered office, which will be at Gurugram, and there can be other offices which will not be a registered office, but they can open these offices at different places of the Delhi NCR, but that all will be done with the consent of the partners, that is partner number 1, 2 and 3. Okay. Moving on to the next clause. This is an important clause which talks about what will be the capital contribution of each partner. So while these partners are entering into this agreement, they should know what partner is having what contribution to this business. Okay. This clause says the initial capital of LLP shall be rupees 10,000 only and shall be contributed by the partners in the following manner. This is just an example. Of course, there will be no LLP which will initially start with a capital of 10,000. This is just for an example. Suppose we are starting an LLP which is having an initial capital of 10,000 and each partner herein agrees to contribute in this manner as herein after laid out in this table. Partner number 1 agrees to contribute 40%, that is rupees 4,000. Partner number 2 agrees to contribute 30% and partner number 3 agrees to contribute 30%. This contribution can be further increased or reduced, but with the consent of all the partners. Okay. If any further capital is required at any time for the purpose of the LLP, the same shall be additionally contributed by the partners in their respective proportion of capital contributions made unless otherwise agreed. So suppose in future they agree, the LLP agrees to increase this capital from 10,000 to 10 lakh, then accordingly the partners will increase their level of contributions. Their level of contribution, but that contribution will be in their respective proportion as have been agreed in this agreement. Suppose this becomes 10 lakh, then also partner number 1 will contribute 40% of that 1 lakh. Partner number 2 will contribute 30% of that 10 lakh and partner number 3 will contribute 30% of that 10 lakh. Okay. Unless otherwise agreed. Of course, if the partners further agree to change this proportion of contribution, they can do so, but that will be in consent with all the other partners. Then comes the clause of profit sharing. How will the profit be shared among the partners? The net profit or loss sharing of LLP arrived at after providing for and deduction of all the costs, charges, expenses, liabilities, debts, and taxes standing to their credit in the books of LLP as of the last date of the relevant financial year shall be divided and distributed among the partner if profit or paid by the partners if loss in the following proportion. So now this table depicts how, if in case there is a profit to the LLP, how will be the profit distributed among the partners, and if in case LLP incurs loss, then how will that loss be recovered from these partners? What will be the proportion they will be liable to clear the debt or to make good the losses that have been incurred by the particular LLP. So now, as partner number 1 contributed 40% to the capital of the LLP, he will be liable to percentage sharing of 40%. Partner number 2 contributed 30%, so he or she will be liable only to the 30% of the profit sharing or the loss sharing. Partner number 3 contributed 30%, so he or she will be liable to 30%, and so on. Then comes cessation. On the cessation of the business of the LLP, all the lawful outstanding dues of the secured and unsecured creditors shall be first paid, and all the other lawful liabilities of the LLP shall be first cleared. The balance, if any, shall be distributed among the partners in profit sharing ratio. If in case there are any changes in the profit sharing ratio upon the mutual consent of the parties, then the same shall apply to the loss sharing ratio. So suppose there is a ceasing of business, there is cessation of business. In that case, all the outstanding dues which are there to be paid to all the creditors, whether they are secured creditors or the unsecured creditors, first they all creditors will be paid, and then whatever is left behind will be distributed among the partners in the said proportion. So suppose an LLP is making a profit of 2 lakhs and it is having a liability of 1 lakh to be paid to, suppose, ABC creditor. So upon the cessation of the business, first the partners mutually will agree and will clear this debt of 1 lakh to be paid to the ABC creditor, and then the remaining 1 lakh amount will be distributed among partner 1, partner 2 and partner 3 in the same proportion in which they have invested in the company. Okay. Suppose if there is any change in the profit ratio, suppose if partner number 1, 2 and 3 mutually agrees and partner number 1 decide that he will be liable to 60% of the profit, and partner number 2 decides that he will be liable only for he will be entitled only for the 10% of the profit, and partner number 3 decides that he will be entitled to the remaining, that is 30% of the profit, then this particular proportion will also be applicable if in case there is a loss. If there is a loss, then also partner number 1 will be liable for 60% to clear those debts. Partner number 2 will be liable to pay 10% of the entire debt, and partner number 3 will be liable to pay 30% of the entire debt. Simple. Okay. Then come restriction on the partner's authority. Without the written consent of the other partners, no partner shall transfer, assign, or mortgage his share of interest in the LLP. So if in case once a partners enter into this agreement and he further wants to transfer or mortgage his part of share, suppose partner number 1 over here wants to mortgage his part of share to some bank, then he can do so, but not without the prior written consent of all the other partners. Okay. On behalf of the LLP, lend money or give credit to or have any dealings with any person whose credit worthiness is doubtful or whom the other partner previously in writing has forbidden to deal with and the defaulting partner shall be solely liable for any loss incurred on account of such breach. If in case any of the partner wants to invest or give money on credit to some other person, which the other partner has not given consent to, then that particular partner who is acting on his sole discretion will be liable for all the losses which are being incurred due to that dealing. Okay. No partner shall enter into any compromise or compound, release or discharge any debt due to the LLP. So if in case there is any debt which has to be paid in the name of the LLP being the separate legal entity, that debt or compromise or any discharge will not be done by a single partner without the consent of the other partners. No partner shall transfer, assign, or otherwise encumber his shares in the asset or profits of the LLP without the consent of the other two partners. No partner shall engage or be concerned or interested in any other businesses directly or indirectly competing with the business of the LLP and do any act that may conflict with his interest with the interest of the LLP or other partners. Okay, any doubt till here? Any doubt, class?
No, ma'am. But can I ask you one thing?
Yes.
So, is it like the LLP is somewhere similar to the Partnership Act that we have in law?
Mhm.
Like, is it similar or not?
Yes, it is similar. The only difference over here is the partners are not co-jointly liable. They are liable only for the particular amount of share they have invested into. Okay.
Oh,
Suppose they have contributed only 1% into the company, and tomorrow the company is having a debt of XYZ amount. He will be liable only for that 1%, no matter if the debt is of 1 crore or 10 crores. He will be liable only for the 1% of the contribution.
ma'am, isn't it the same in Partnership Act also? Like,
No, their partners are co-jointly responsible. Suppose there is a debt of 50,000, okay, and there are two partners. No matter they have contributed 10%, no matter they have contributed 20%, both of them will be liable to clear the debt, either 25% or as per mutually agreed between them.
okay, ma'am. But then I remember there is some section wherein it is written that like if A had contributed 10,000, then A will be liable up to 10,000 only and not beyond that.
So that comes under LLP.
Okay, ma'am.
It's similar to that, but there are some minor changes. Here, it's specifically in partnership, also, you can have that clause, okay.
Yes,
But in
ma'am.
LLP, the term in itself defines limited liability. You cannot extend the liability of a particular partner beyond a certain contribution they have made to the company.
Okay, ma'am.
Either that is in the case of profit making or in the case of loss making.
Yes, ma'am, I got it. What I was asking about. It is written jointly liable. I was
Yes.
wrong. Yes.
Yes. Now comes how will the management and meetings of the LLP will take place. The overall management of the LLP will be conducted by the partners of the LLP collectively. Any matter or issue relating to the limited liability partnership, including but not limited to the admission of new partner, resignation of any partners, death of any of the partners, infusion of capital, increment or decrement of profit and loss sharing ratio, etc., shall be decided by a resolution passed by the partners, and for this purpose, each partner shall have one vote. So what we have decided over here is that in case suppose this LLP is having three partners, and tomorrow if partner number 4 comes in, give me a second. Suppose tomorrow Mr. X comes and proposes to be a partner in this. Then for the admission of Mr. X, each of the earlier partners, that were partner 1, 2, and 3, will have one vote. He will come into the LLP as a partner only if there is a majority voting. Suppose 2 out of these 3 partners have voted in favor of his admission, then only he will come. And then only and accordingly his particular contribution will be decided, as has been agreed by the voting. Okay. Similarly is the case if in case partner number 2 decides to resign, then also there will be a voting among partner number 1, 3, and X, and they will decide how the resignation will take place and now what will be the proportion of the profit and loss sharing ratio. Okay. The meeting of the partners shall be called by sending 7 days prior notice to the partners at their residential addresses or by email at their email IDs as registered with the ROC at the time of allotment of the DPIN or at the email IDs provided by the individual partners in writing. So the circular for this meeting will be circulated to all the partners either at the residential addresses or to the email IDs as have been registered with the ROC. The meeting of partners shall accordingly be held at the registered office of the LLP or any other place as mutually agreed between them. Then the limited liability partnership shall ensure that decisions taken by it are recorded in minutes within 30 days of taking such decisions and are kept and maintained with the registered office of the LLP. The meetings of LLP and the maintenance of minutes of meetings shall be mutually agreed between the partners. A resolution circulated in writing and signed by the partners, as the case may be, shall be deemed to be duly passed, and the date of passing of such circular shall be the date of signature of the person who signs the same at last. So, how will this process will take place? First, there will be a notice or a circular circulated to all the partners. Suppose we are planning to take up a meeting on 7th of June, then that particular notice will be circulated at least on 1st or 2nd of June on their registered email addresses or their residential addresses. Then a meeting will be held either at the registered office or at any other place as will be mutually decided by the parties. Then they will ensure that whatever decisions they are taking during that meeting is recorded in the minutes of that meeting, and that minutes of meeting will be in writing and will be maintained as a record with the registered address of the LLP. Okay, then that resolution circulated in the writing will be held as duly passed only once all the partners sign that particular resolution circular, and the date of that circular will be deemed as the date of passing of that particular resolution. Any doubt in the process? Any doubt?
No, ma'am.
Okay. Then comes the admission of LLP. No partner may be introduced as a new partner of LLP without the consent of all the existing partners. Such incoming partner shall give his prior consent to act as a partner of the LLP. So there will be no new partner introduced in an LLP, as we have discussed, without the consent of the already existing partners. Like I gave an example over here, that if Mr. X wants to enter the company, Mr. X wants to enter the LLP, then there is a prerequisite that partner number 1, 2, and 3 will enter into the voting, will pass a resolution, and then Mr. X will come into the picture as a partner. The contribution of the new partner may be tangible, intangible, movable, or immovable property, and the incoming partner shall bring minimum contribution of 50,000 on or as may be decided by the existing partners from time to time. So here what we are saying that the contribution of new partner can be anything. Either it can be a movable or immovable property or a tangible or intangible property, but that incoming partner should at least contribute 50,000. So because here we were taking 10,000 as the initial capital, so it's kind of accordingly it's kept minimum to 50,000, but it can be according to the terms and agreement between the partners of that LLP. It's again a subjective clause, and that existing partners' contributions can be decided between the partners from time to time. The profit sharing ratio of the incoming partner will be decided by the existing partners as per the mutual consent, as discussed. Any particular contribution which he will make will further depict in the profit and loss sharing ratio, which will again loss sharing ratio, which will again be in consonance with whatever he is contributing. Suppose he is contributing 20% to the LLP, so his profit and loss sharing ratio will also be 20%. But all this has to be decided by the mutual consent of all the existing partners of the company. Any person having any business interest which is in conflict with the business of LLP shall not be admitted as a partner of LLP. This is again important, that any person who is having any kind of conflict with the business of that LLP will never be admitted as a partner of that LLP. Persons admitted as partners shall duly comply with the provisions of 25 subclause 1 of the LLP Act and rule so and so. The LLP shall have a perpetual succession, and the death, retirement, expulsion, cessation, or insolvency of any partner shall not dissolve the LLP. So, what this clause means is LLP in itself is having a separate legal entity. And if in case partner number 1 tomorrow, partner number 2 tomorrow is declared as insolvent by the NCLT, then that will not affect the legal entity of the LLP. He will be the person who will be terminated. He will be the person who will be expelled from this LLP by the mutual agreement and by the passing of the resolution. But that in no way will affect the individual capacity or the legal entity of the LLP. Okay? Getting it? Now there are certain other clauses which I have written over here. These are some of the clauses which will depend, which are subjective to what kind of LLP and what kind of business will be run by that LLP. So we'll discuss these clauses in the next class. For today, I'm binding up the class over here. Any doubt in this? Any doubt? Any doubt, class, in the LLP or in the asset management agreement or in any sort of consultancy agreement or whatever we have discussed till date? Or you want me to pick up something particular? Because on the next class also I'll be discussing more clauses of this LLP, and then we'll further go into the kindly share the consultancy. Okay. Okay, I'll share it again. I guess I've shared it with you, Paras. If you can check it once.
Okay, ma'am. If I have not received it, I will tell you.
Yes, please check because I guess I have shared. If not, I'll share it with you. Yes, okay. I guess I asked not to share and asked you guys to draft the one. Okay, I'll share that agreement. And I'll be sharing this LLP agreement I'll be sharing the hotel asset management agreement, and I want you guys to work upon this agreement, LLP agreement, and let me know in the next class what all clauses are remaining in this and what extra can we add to this particular agreement. Okay. I want some inputs from your side. Just give me a second.
If anybody have any query, you may ask, or otherwise we will wind up the session. Ayaz, Bhavya, Naseem, Ojasvi,
Ma'am,
Paras.
when will be the next session will be held and at what time? Because you know that we should fix one particular time, otherwise we
Yes.
will not manage other
For the
activities.
next week, we'll have a class on Saturday, and then the second class will be on Sunday. Okay. And timings can be either it can be morning. Yes, it's better to have it in the morning if possible.
In Saturday, I believe that we should conduct in evening, and then on Sunday, if we on the same time like 11 o'clock, then it will be fine.
Okay, on Saturday we can have a class in the evening. I'll let you know at what time after 4. And for Sunday, yes, we can have it at the same time, 10 to 11.
Yeah, sure. Thank you, ma'am.
Okay, I
Ma'am,
guess yes, Ojasvi.
ma'am, one little suggestion. So while we are doing this class,
Mhm.
so just to make it more interactive, we can do one thing that you can say the main heading as in like this is the thing that we need to be drafted, and we can give our statements like this can be the statement under that topic. If you are getting what I'm saying.
I did not get your point. So
Um,
you are asking me that suppose I'm drafting an LLP agreement, so I should give the heading business of
right.
LLP and then ask
Yes.
you guys to draft a clause.
Yes,
In
ma'am.
advance, she is saying that in advance, please provide the title of the things we are going to do in the next class.
Okay, in advance, you want me to give you the titles and then you can accordingly draft and come up with
Yes,
the
ma'am.
clauses.
Yeah, because
Yes,
if
yes,
you
yes,
give
yes,
us the
perfectly.
whole thing, then obviously we have already read it. So the same statement comes to our mind. So there is like no way we can. I mean, there is a way, but obviously the first thing we'll be
Of
like
course,
to
I'll do
read.
one thing. Like I have shared important clauses for the consultancy agreement, and I asked you guys to just draft a consultancy agreement. So similarly, I'll do one thing. I'll share all the important clauses of the partnership agreement, and on the next class, which is on Saturday, you can come up with the remaining clauses of the LLP agreements and you can come up prepared for the partnership agreement, and then we can draft simultaneously. Okay.
Yes, ma'am. That is better.
Okay, thank you.
Ma'am,
Thank
and on Saturday, can we do the class in the morning itself?
Sorry,
On Saturday, can we do the class on morning itself?
I
Like,
was prepared for morning only, but I guess Ajas or one of you asked to have it in the evening. If
ma'am,
maximum, if majority
Sunday.
decides to have it in the morning, because next week, yes, it's possible to for me to have it in the morning as well as in the evening. So you guys decide whatever the majority will decide. Paras, please do let me know, and accordingly we can schedule a class.
Yes, ma'am. The
Yes,
admin can make a poll and put it on the
Yes,
board.
whatever the majority wants, either we can have it in the morning from 10 to 11 or in the evening after 4.
Okay. Thank you, ma'am.
Okay, thank you. There's one difference between dissolution of partnership and partnership. You mean LLP and partnership? Okay, we'll discuss this in the next class. I guess everyone is left. I have noted this query. We'll take up this query in the next class.
Okay, ma'am. And thank you so much for taking the session. And I would like to request everyone kindly go through with the PPTs and videos, and the MCQ assessment will be happen soon.